So here's some Colorado case law on felony menacing. Colorado case law on felony menacing. Here we go. In the 1992 Zeig decision, this is COA, Colorado, or the Court of Appeals, William F. Zeig swung an axe twice at the front door of his neighbor's house, who had just called the police on him for partying too loud. William F. Zeig was threatening to rip his neighbors' heads off, and when William F. Zeig axed their door twice, it shook the whole building. So he's partying, making noise, neighbors calls the cops, he's pissed off. Once the cops leave, he goes over to their house with an axe, and he hits the front door 2 times, felony menacing. That was the 1992 Zeig decision, named after William F. Zeig. In the 1986 Breland decision, again, Court of Appeals, after Hollis R. Breland had offered Larry Statz some pills and cocaine back at Hollis R. Breland's abode, Hollis R. Breland pulled a gun out and pointed it right at Larry Statz, an off-duty deputy sheriff. And cocked it, declaring, "You're a dead son of a bitch," right before Larry Statz grabbed the barrel of the gun, saving himself. Then a fight broke out. While Larry and Hollis were fighting, the gun goes off. Larry Statz gets away from Hollis R. Breland, and he takes Hollis R. Breland's gun with him. Later on, when Larry Statz and others goes to arrest Hollis R. Breland again tries to shoot a police officer at close range. In the 1980 McPherson decision, this is a Supreme Court case, not just an appeals case. This is a Supreme Court case. Martin J. McPherson, while drunk, takes a rifle into a dormitory, pointing it at the night clerk, an 18-year-old female student, and then pointed the rifle at 2 random people coming out of an elevator, holding all 3 hostage for some minutes. One tried to run but stopped when Martin J. McPherson ordered them to stop. As Martin J. McPherson left the dormitory, he threatened, "I have a high-powered rifle here, and if anyone touches that phone, I'll blow a hole right through you." That's when they used to have phones on the... So 1980 McPherson decision. This is an interesting decision. I'm going to make a note. This is one of those decisions that the Supreme Court absolutely lives for. They absolutely live for it. This guy, McPherson, he's drunk as shit. He thinks that, some guy had threatened him on the street, so he went home and got his rifle, and now he's looking for that man on the street. He don't know where that man went. He don't know if he's in that dormitory, where the hell he went. He's drunk as shit. Maybe the guy did threaten him, but now he went, to his house, grabbed a rifle, and what's he going to do with that rifle? He's going to hold an 18-year-old up. He's drunk, don't forget. Okay, so he's holding an 18-year-old clerk up. He says, "Take me to the roof," goes to the elevators. 2 people come out. Now he's holding 3 people up. 3 people are being held up. And what was why did the Supreme Court case even pick this case up? Well, Martin J. McPherson says it wasn't felony menacing because his gun wasn't loaded. And since his gun wasn't loaded, he wasn't trying to, menace anybody. He wasn't trying to felony menace anybody. The gun wasn't even loaded. Basically, it was one big April Fool's prank, one big April Fool's joke. The Supreme Court is going to make the correct decision. The Supreme Court will make the correct decision and says that in this instance, a rifle that he acts is loaded and people act like it's loaded, and then that's just based on his word. Did we grab the rifle to see if it was loaded or not? We have no idea if he's telling the truth. But the Supreme Court was like, interesting. If the gun wasn't loaded, then he couldn't have actually tried to cause fear. The whole thing is to cause fear in another person. Can you cause fear in another person with an unloaded gun? Yeah. I mean, if you think it is, or you're acting like and they think it is, technically, it's not a deadly weapon. Technically, it's not a deadly weapon. Well, it didn't have it didn't have any... That gun didn't have no bullets. And when I think about what was that, Hamir Rice, he got shot and killed for holding a squirt gun. In In the 1996 17th District Court decision, again, Colorado Supreme Court, right after Travis Henry had just stabbed Desmond Carter to death with a butcher knife, Travis Henry then threatens to kill Joyce Pittman if she doesn't leave the room and therefore the house immediately. And when Travis Henry threatened to kill Joyce Pittman, that's felony menacing. Travis Henry and Desmond Carter and Joyce Pittman had been smoking crack cocaine. Early that morning, this was in Aurora. Travis Henry claimed Desmond Carter and Joyce Pittman tried to rob him. Joyce Pittman hit Travis Henry with a lamp and a board as he was stabbing Desmond Carter to death. So, clearly, right, that's felony menacing, but a lot of other stuff too. Murder. There's murder and there's felony menacing. In the 1977 Stout decision, again, Colorado Supreme Court, 1977, that last one was a 1996 17th District Court decision. In the 1977 Stout decision, Colorado Supreme Court, Clarence O. Stout in his car was chasing Mr. Cram and his son in their car. Clarence O. Stout tried to ram Mr. Cram's car off the road. Clarence O. Stout at one point made a wild right turn from the left-hand lane in order to continue pursuit. So it doesn't get into, the ride. Not only did Mr. Cram and his son see Clarence O. Stout pointing his rifle out of the car, but so did an off-duty deputy sheriff and his wife. 4 people saw Clarence O. Stout sticking his rifle out of the car as he was chasing and trying to ram him off the road. And then when they parked, he pointed the rifle out of the car again. Clarence O. Stout claimed he only picked up his rifle because the strap had gotten stuck in the gear shift and that he only had the rifle in the first place because he was doing some target practice that day. At an alcohol bar in the 2018 Copper decision, Koper, Colorado Supreme or Appeals Court of Appeals, Mr. Copper, 2018, so recent, fairly recent, Mr. Copper said something to Abraham's sister, which had offended Abraham. Mr. Copper tried to make amends by offering to buy Abraham a beer, but instead, Abraham punches Mr. Copper twice in the face. Mr. Copper then pulls his gun out, and he keeps it pointed at Abraham for a bit. Then Mr. Copper gives his gun to his fiancée, and they both leave the bar. In the 1998 Saltray decision, Colorado Court of Appeals, Robert G. Saltray seems to be jokingly felony menacing his friendly neighbor who just said hello to him. Why? Because Robert G. Saltray wanted to impress the woman that he was talking to. Robert G. Saltray's apparent victim never saw the gun that was pointed at him or any of the incident at all. And then last but not least, so we're looking at 8. This is all good laws, 2022. In the 1977 Johns decision. Now, this is also Colo Supreme Court case. This is named after Doyle T. Johns, the DA of Sedgwick County at the time. And we get to witness in this case, State Patrol Officer McEntee is going to commit felony menacing several times over during an arrest over reckless driving against Mr. Best. So Officer McEntee is going to, during an arrest over reckless driving against Mr. Best. Interesting. So not just a police officer, but the state police. The state police. So what can we conclude? We can conclude a bunch of things. First of all, what's the spirit? What's the spirit of the law? You got this guy, William F. Zig. He's got an axe, right? He takes an axe twice to the front door of his neighbors for no rhyme or reason. He's not protecting his property. He's not protecting his home or anything else. He's just pissed. And he's probably drunk. He's pissed and he's drunk and he's partying too loud. They called the cops on him. The cops said, hey, you need to quiet down. People are trying to sleep. And that pissed him off. How dare you ruin my party? I'm drunk and it's my party and I can cry if I want to. So he goes over to his house with an axe, hits the door twice, felony menacing. In 1986, the Breland decision, this is completely... Larry Statz goes to Hollis R. Breland's house for some cocaine and for some pills. And then something happens where Hollis R. Breland then pulls a gun out on Larry Statz. And now they're going to say, well, he was a cop the whole time. Why did he go to his house? He offered me some pills and cocaine. Oh, you were doing police work? Or in the middle of the police work, what happened? And then when Larry Statz points the gun at him, and this is just from the police officer's perspective, he says, you're a dead son of a bitch. And then that was felony menacing. And if we take it on, at face value, a fight's going to break out. The gun's going to go off. When they come back and arrest him later, Hollis R. Breland again tries to shoot one of the arresting police officers. So, I'm inclined to believe that Hollis R. Breland pulled a gun out and went to go shoot Larry Statz, and Larry Statz grabbed the barrel and basically saved his own life. I just got some questions. With that case. And the point is, put all these together. And what's the essence? What's the essence of the law? Okay? So when we put them all together, the McAtee, the State Patrol Officer McAtee, when he committed felony menacing, he points a gun at Mr. Best. He threatens to, Mr. Best, you want to fight? Oh yeah, Mr. Best, I'll put the gun in the trunk and we'll fight. Then he stops at an abandoned gas station and he opens the door and he tells Mr. Best to go run. Hey, Mr. Best, you think you're such a hot shit punk? Okay, punk, why don't you go run, punk? You know what we do to punks like you? We blow a hole through him. Go ahead, try to run, punk. Go ahead, try to run, punk. And that's interesting. Do you know what we do to punks like you? In 1977, were cops just shooting people left and right? I mean, they kind of do it today. Okay, so we got 8 cases here, right? So this case here, he pointed the gun at him. He says, do you want to fight? And he says, why don't you go ahead and run? I'll shoot. Sultry. He seems to joke, jokingly with his neighbor, but he's pointing a gun at him. So again, we got, one time the gun is being pointed right at the guy, point blank range, right? Hollis R. Breland, point blank range, points a gun at Larry Statz. The McPherson decision, it's unloaded, so, he really wasn't menacing anybody. No, he menaced everybody that night. It's crazy it even got that far up the damn ladder. But he pointed a gun at the night clerk and he pointed the gun at 2 people in the elevator. What are we supposed to do? We were supposed to tackle Martin J. McPherson and then look at his gun and say, well, shit, there wasn't no damn bullets in it. He was just joking. This is just a spoof. That damn Martin J. McPherson was just spoofing us. The 17th District Court, 1996, 17th District Court decision. A lot of shit is happening. But if you kill the crap out of somebody and then you turn to the other person in the room and say, you better get out of here or I'm going to do it to you too, that's felony menacing. I mean, it's probably more, right? I mean, there's murder, right? He murdered, but he felony menaced the second person. So that was with a butcher knife, okay? So several times we got, here's one with a gun, here's one with a gun, with a rifle, and apparently with a handgun, a high-powered rifle. Martin J. McPherson announced, I got a high-powered rifle here, and if anyone touches that phone, I'll blow a hole right through you. They all believe that there is in it, and then we're supposed to believe McPherson's words later? It wasn't loaded. Well, we got to figure out if it was or wasn't loaded. Is that felony? I don't know. Send it up to the Supreme Court. They'll figure that out. In the Stout decision, Clarence O. Stout is chasing Mr. Cram. He's chasing him. He tries to ram Mr. Cram's car off the road. And there's one point he makes a crazy turn. And not only did Mr. Cram and his son see him with a gun, because you might say, well, it's just between them two. There's only those two, so they're both biased. No, there's an off-duty deputy sheriff and his wife who also witnessed it too. So 4 people witnessed Clarence O. Stout sticking a rifle out at somebody while driving a car. at an alcohol bar, the 2018 Copper decision. The guy said something to Abraham's sister, which who knows what. Hey, nice ass, right? Hey, there's some nice tits. Damn, look at the tits on you. That offends Abraham. Oh, I'm offended, you son of a bitch. No, I'm so pissed off. Why don't you get the hell out of here? Well, man, I didn't mean it. How about it? I was just giving her a compliment. We're all drunk. We're having a good time. Let me buy you a beer. Let me buy you a beer, Abraham. I told you to get the hell out of here. Let me buy you a beer. Boom, boom. Punches him twice in the face. Copper pulls a gun out. There again. Pulling guns out. Right in front of them. They're only 10 feet away. Right? They're 10 feet away. In the Breland decision, apparently they're in the apartment, so they're only 10 feet away. In the McPherson decision, right at the night clerk and then at the elevator, they're only 10 feet away or less. The Johns decision, he points right at the guy in the back seat. So that's less than what? 3 feet? So it's imminent serious bodily injury. Whenever you threaten imminent serious bodily injury. So the gun in a person's face is serious bodily injury. An axe at the door. You just take an axe at someone's door. If you're butchering somebody with a butcher knife, and then you say, you better get out of here, that's also felony menacing. And then the last case, the Sultry decision, which I already mentioned, was I think he was joking, but there was a danger there because he was pointing a gun at the guy and he was making it seem like he would have shot him or he was going to shoot him or something. I think I understand what was going on there, but I've been more likely to believe that gun was unloaded than the McPherson gun. So what's the conclusion? The conclusion is you have to be a criminal piece of shit doing some criminal shit to some other person for no rhyme or reason. I mean, there's one of these or a couple of these you might be able to say it was self-defense. It was self-defense, right? Robert G. Sultry, yeah, he might have said some shit he shouldn't have said. Maybe he didn't say. Maybe the guy is just, overly, or not Sultry. Copper, Mr. Copper. Maybe he said something to Abraham's sister, which offended Abraham. Or maybe Abraham is just a pissy fucking, dickhead. And so, Mr. Pissy Dickhead is just, being, punches a guy because he just wants to punch a guy. Well, that's assault. You can't assault somebody. And if Mr. Copper thought that Abraham was going to keep on punching him, he had a right to defend himself. He pulls the gun out, that stops the punches, and then he gives the gun to his fiancée, and then they leave the bar. So nothing happens, right? But if you're trying to, and then that case is interesting because Abraham doesn't file charges, but there's two people at the bar that filed charges, or the charges were filed on their behalf. And so there's two people that was at the bar, right? There's two people at the bar when he pointed the gun at Abraham. They said that they felt like a crime had happened to them because he could have shot them as an innocent bystander. And so what that case brings up is the transference, the transference principle, where if I intended to hurt a bunch of people and an innocent bystander got hurt, well, I'm guilty of hurting that innocent bystander because I intended to hurt a bunch of people. But if I have a gun and I'm trying to save people, and I try to save a person's life, and I end up shooting an innocent bystander, a time to kill. And a time to kill, the guy kills the two, rapists, the two guys that raped his child, but he also he shot another guy in the guy's leg. But when the guy was testifying, he was like, you know what, I don't put it past him. It's okay that he shot me. Objection! I'm okay that he shot me in the leg, because to hell with those two guys. So the whole idea was transference. He was shooting the two bad guys. There was a bystander. And so it depends on what the initial attack was about. You were, shooting some bad guys and you hit an innocent bystander, then you're okay. If you were, going after some good guys or you're just a criminal felon, piece of shit, that is not okay. So the transference is if you hit an innocent bystander, it matters the initial incident. What were you doing with the initial incident? So taking this all together, a bunch of shitty people doing a bunch of shitty things. Several times you got the gun just being pointed right at the person's face. In the same room, in the same vicinity, within 1, 2, 3, maybe 10 feet at the most. Yeah, there's nobody like sniping, right? There's nobody like up on top of a building that's. And so that's my conclusion is when I think about the spirit of the laws, when you put all these cases together, what are the spirit of the laws? The spirit of the laws, people might. I could see a police officer doing some of this, the copper decision. But the spirit of the law is you can't go around trying to scare people with imminent serious bodily injury. You can't scare people with imminent serious bodily injury. Not only was Clarence A. Stout pointing a rifle out of his car, he was driving a car too. And a car is a deadly weapon. You can use a car to kill people. Suge Knight ran over that guy. A car is a deadly weapon. So you can't use a butcher knife. You can't use a car. You can't use a rifle. You can't use an axe. You can't use any kind of weapons. It has to be a deadly weapon. That's felony menacing. You try to cause imminent serious bodily injury with a deadly weapon. So that's the conclusions. Now, I want to point out, I guess last but not least, because I kind of go through each one of these court cases a little bit more particular. But Doyle T. Johns. I want to talk about the Johns case. The 1977 Johns decision. The prosecutor, he was actually brave enough to charge a police officer for felony menacing, a crime he actually committed. He's trying to effectuate arrest, and then we give cops all the leeway in the world, but the trial judge, he didn't have the same bravery. So Doyle T. Johns, the prosecutor, files charges against the police officer, but the trial judge, he says this: I don't think that there's been sufficient evidence to establish probable cause that this officer committed the crime of felony menacing. Really? There's not sufficient evidence to establish probable cause? You have Mr. Best. Mr. Best testified that he witnessed, that he saw McEntee point a gun at him, threatened to beat him up, and then open the door. Why don't you go ahead and run? Implying that if he would have gone ahead and ran, he would have shot him in the back. He would have shot and killed him in the back. But the trial judge, I don't think there's been sufficient evidence to establish probable cause. Really? There hasn't been sufficient evidence to establish probable cause. Motherfucker could just say some shit, and then some other motherfucker could see some shit, and then he could tell the judge, and somehow that's probable cause. But this ain't probable. Okay. I don't think there's been this. Mr. Best is a big guy. Mr. Best is a big guy, and he's been drinking, and undoubtedly, he was mouthing off, as he said. He called the officer a pig. I don't think that the officer has to wait until he's struck or shot at before he's justified in drawing a gun. That's why we have them. At least it isn't sufficient conduct that would justify going to trial on the 5th class felony. I don't think that any felony was committed. So the reason why the trial judge would say some shit like that, the reason why these judges and prosecutors rubber stamp these cops' decisions, well, they're a bunch of pussies. They're a bunch of fucking weak-ass pussies. They don't want to make the arrest. They don't want to have to put themselves in danger. So they like to have some goon, some, strong man go out there and make the arrest for them, and then they'll go ahead and rubber stamp them. And then that way later on, right, you scratch my back, I scratch yours. Yeah, okay, I'll say that was a good arrest, but hey, I got somebody, who's stalking, whatever. I got something for you to do for me. So the trial judge, he didn't see no probable cause, because I believe if you would have just reversed the roles, the way you can tell if something is fair or not, just reverse the roles. Just reverse the roles. So this isn't what happened. This is what would have happened if you reversed the roles. So what happened, just reverse the roles. But I'm going to say it as if Mr. Best is going to hurt the police officer, right? Mr. McEntee is the cop. Mr. Best is the civilian. So Mr. Best, civilian, goes up to Mr. McEntee, right? And Mr. McEntee is just hanging out with the buddy. He's a police officer, right? This cop is just hanging out with the buddy at some parking lot. Well, Mr. Best thinks that's suspicious. What are you two cops doing over here? He searches them, and he finds probable cause to citizens arrest him. He didn't find anything in the search, but they were doing reckless driving. So Mr. Best arrests the cop, for reckless driving. He witnessed reckless driving. He's arresting the cop. Now, it's legal in Colorado to citizens arrest. Now, he takes Mr. McEntee, the state patrol officer, who he witnessed reckless driving, and he puts him into the squad car, and it's unmarked, so it looks like Mr. Best is just taking this cop and he's putting it in the back seat of his regular, plain old sedan. Now, Mr. McEntee asks why he's being arrested, and he asked his stupid question 2 times in a row. Why would that cop ask why he's being arrested? Shut the hell up. Mr. Best knows what the hell he's doing, and he saw you get arrested. He don't have to answer none of your damn questions. But Mr. McEntee asked it twice. Mr. Best doesn't like Mr. McEntee's, bullshit. You're going to ask me why I just put you in a car and why I'm taking you into jail? Well, this irritates Mr. McEntee, who dismissively calls Mr. Best some kind of pig. Well, you're some kind of pig. Oh, well, shit. That just sets Mr. Best off. The official police officer, he pulls his gun out. He points it right into Mr. McEntee's face. Mr. Best calls McEntee a punk. And then Mr. Best puts his gun away, puts handcuffs on Mr. McEntee, and then takes the cop and he moves him from the back seat to the front seat of his unmarked so-called patrol car. Mr. Best is still pissed off that, some kind of pig remark. He's still calling Mr. McEntee a punk. And then he challenges Mr. McEntee to a fight. Well, Mr. McEntee's not afraid of Mr. Best. Mr. Best is, something about he just got started and he can't stop. Mr. McEntee suggests a referee, but once again, this sets Mr. Best off. Oh, you want a ref? Well, I'll fight you. Just get a referee. Oh, yeah? Oh, yeah? Mr. Best pulls into an abandoned gas station. He gets out of his car and he opens Mr. McEntee's door and he dares him to run. Mr. McEntee again calmly, maturely de-escalates the situation and suggests that Mr. Best just take him straight to jail. Isn't that crazy? Mr. McEntee, the cop who basically, who the hell is this Mr. Best? What the hell are you arresting this guy for? But it's the cop who's being arrested that's actually being calm and mature. Now, if Mr. Best had done all that to Mr. McEntee, you think that trial judge would have had a problem with finding probable cause? You arrested a cop for reckless driving. You searched him, and he sat in the car. You pointed a gun in his face. You pointed a gun in his face. You think the trial judge would have been like, well, you got to threaten to fight him. You got to open the door and say, why don't you go ahead and run? You got to point a gun in the guy's face if he keeps asking dumb questions. He asked a bunch of dumb questions. You gotta point that damn gun. You think the trial judge would just go ahead and forgive Mr. Best like it wasn't nothing if Mr. Best, a civilian, a citizen, arrested a police officer? If we just reversed the roles. But that's not what happened. Mr. McEntee did all that to Mr. Best. And then the trial judge, he couldn't see any felony menacing. And so what the Supreme Court of Colorado, they saw felony menacing. And they said to go ahead and reinstate the charges. So, yeah. William F. Z took an axe to his neighbor's door for calling the police on him for partying too loudly. Hollis R. Breland pointed his gun right at Larry Stats, not 10 feet or so away for some unknown reason. Martin J. McPherson pointed a rifle at a night clerk and at 2 random people in an elevator both 10 feet away or so. Travis Pittman stabbed and killed Desmond Carter with a butcher knife and then threatened to kill Joyce Pittman if she didn't leave. In the 1970s, Clarence O. Stout had threatened Mr. Cram and his son imminent serious bodily injury with both his rifle and his car. Both deadly dangerous weapons for no rhyme or reason. Mr. Copper pulled his gun at a bar not 10 feet away from Abraham Robert G. Saltree, pointed a revolver at a neighbor who peacefully walked out to his car. Now, he might have been some distance. He might have been 100 feet or so away. Maybe not 100 feet, maybe 50 feet away. I don't know. The guy didn't see any of it. And a guy named McEntee pointed a gun at close range at a guy named Mr. Best, who was sitting in the back seat of McEntee's sedan. McEntee also opened Mr. Best's car door, dared him to run, insinuating if he had, he would have shot him in the back. So what's the spirit of all this? Most of these felony menacing cases are of terrible people doing terrible things to other people. They're criminals committing crimes. One may have been in self-defense, but the rest of them, they're threatening imminent serious bodily injury. We need to keep felony menacing as a charge, as